Good morning, everyone. Welcome to the Fasken seminar on Telecom, Broadcasting and Media Trends 2023. My name is Leslie Milton, and I'm co-chair of the TMT group at Fasken. That's the Technology, Media and Telecommunications group. It's exciting to have some people here in person with us in Ottawa and Toronto, and to have lots of people online as well. We've queued up a series of short sessions, short presentations this morning on current issues in communications. The topics range from what's going on with broadcasting and online news, to Indigenous reconciliation, to AI and privacy, to film and television production tax incentives, to the right to be forgotten in this digital world that we now live in, and finally to plain old telecom regulation. Our speakers are all members of the Fasken Communication Group, which is one part of the TMT group. Our bios are available in the presentation materials, which I expect will be circulated after the session and also on our website. We're going to cover quite a lot of ground this morning quite quickly. We hope to have time to take questions both from the floor and through the chat during or after each session. If you still have questions, please feel free to come up to us during the break, after the session, or reach out to us virtually. Now, if I could ask you to look to the screen quickly, I believe there's a slide with some administrative issues, particularly if you're online, how in particular you might ask questions or get tech support. So with that by way of background, I'm going to turn it over to our first speaker, Paul Burbank. Paul is an associate in our Toronto office. He is very active on communications and tech matters. Paul is going to speak to us this morning on online news legislation. Paul, over to you.
Perfect. Thanks so much, Leslie. So the title of my presentation is called Canada's Online News Act Explained. But I won't mince words about this fact. 15 minutes is not enough time to explain all of the nuances, all the details of this legislation. Many people watching this seminar are probably quite familiar with this. What I've done today is I've decided to try and bite off a chunk of it and explain the context in which what we're seeing in the news is taking place so that we can get a better sense of what news actors are going to be doing as we move forward. So maybe we can move to the next slide. So I thought maybe I'd start by talking a little bit about the underlying policy rationale of the legislation. So according to government estimates in 2021, online advertising revenues in Canada reached $12.3 billion, with Google and Meta having a combined share of 79% of these revenues. So this doesn't mean that in providing Canadians with access to news, digital platforms do not provide news businesses with benefits. These news platforms provide links to news content. They drive readers to news services who own the copyright in the news itself, and they're able to monetize that traffic through digital advertising and subscriptions. But principally and undeniably, digital platforms are deriving a sizable and increasing share of revenues associated with advertising on online news services. And the net effect is that news services continue to see declines in advertising revenue. Meanwhile, producing high quality, trusted news journalism is not getting any cheaper. A report filed on the public record in a recent CRTC proceeding by the Canadian Association of Broadcasters, for example, estimates that Canada's private broadcasters and the print media industry collectively invest close to $1.1 billion annually in producing news, with broadcasters making up 60% of that investment. Obviously, these are very high level, back of the napkin figures that we could unpack just like any data point. But the point is, they point to what I think is an obvious dilemma, and that's that news is expensive as ever to produce at the same time that revenues are declining. And my view is that journalism is a public good. Trusted, unbiased journalism is critical in an era where Canadians receive information from a variety of sources online, where the legitimacy or veracity of that information is often hard to assess. And news is critical to Canadians being aware of what's important in their local communities and Canada's place in the world. And so substantial resources are required to make these significant investments. And the Online News Act is intended to be just one policy tool that can achieve that. There are other policy tools at the federal government's disposal, For example, they created the Canadian Journalism Labor Tax Credit, which is only available to the print media industry and excludes Canadian broadcasters for a reason that's never been particularly clear to me. So the criticism that will inevitably follow of this bill, of this legislation, is not an indictment of the policy intent, nor is it a criticism of stakeholders from either side, but rather political officials that have pushed us to the brink of the situation in which we now find ourselves. And I'm going to speak more about that situation in just one moment. Next slide, please. So that's the policy background. I'm not going to wax on about policy all day, because at the end of the day, we're lawyers. We're giving out CPD for this, so we need to actually talk about the legislation. And so, like any piece of legislation, let's start with the definitions. The Act applies to digital news intermediaries principally. It means that, and digital news intermediaries mean an online communications platform, including a search engine or social media service, that is subject to the legislative authority of Parliament, and importantly, and that makes news content produced by news outlets available to persons in Canada. And maybe if we jump to the bottom right side of the screen there, you'll see that there's an interpretation clause that, you can go back one slide there, Andrea. Thank you. There's an interpretation clause that explains what making available news content is. And it's really important that we look at this for just one moment. It says, for the purpose of this act, news content is made available if the news content or any portion of it is reproduced, or B, access to the news content or any portion of it is facilitated by any means. So under sub A, if an online communications platform reproduces a portion of the news, including, for example, the title and maybe the first sentence, first paragraph, obviously that would be reproducing a portion of the news. In fact, reproducing a copyrightable portion of that news. But even if an online communications platform doesn't necessarily reproduce elements of the news itself, for example, if they merely provide a link to that news content and nothing more, it is still facilitating access within the meaning of sub B, meaning that online communications platform would be captured by the legislation. And that's not a defect of the legislation. That's not an interpretive gap. That was very much the intention. Canadian heritage officials came to the legislative process and they explained that, yes, including links to news content with nothing more is intended to trigger the obligation that comes with being a digital news intermediary. And so maybe we can skip to the next slide. But the Act itself doesn't necessarily apply to all digital news intermediaries. It only applies to a certain set. And this is what we've been referring to as the bargaining imbalance test. The Act applies in respect of digital news intermediaries if, having regard to certain factors, there's a significant bargaining power imbalance between the operator of the digital news intermediary and news businesses. I'm going to talk a little bit more about the regulations in a minute, but essentially in the regulations, the Governing Council has set out exactly what this bargaining power imbalance test means and how it should be interpreted. But for that purpose, if you meet that test, you are a digital news intermediary and the Act applies to that digital news intermediary. And then from there, there's two paths. On the bottom left corner, the digital news intermediary could enter into enough commercial agreements to satisfy the CRTC that it meets the exemption criteria in the Act and have the CRTC issue an exemption order. Or it can engage in mandated bargaining and baseball-style final offer arbitration with every single eligible news business in the country. Those are the two principal options, and they're not necessarily mutually exclusive. A digital news intermediary, the way the Act is designed, with a cascading coming into force provisions where the exemption process can begin before the arbitration can be, the bargaining and arbitration can be triggered, gives a digital news intermediary the opportunity to try to enter enough commercial agreements that it satisfies the exemption criteria. And if that does not happen after a set period of time, then news businesses can trigger that bargaining process. The remainder of my presentation is going to focus on the box in the bottom left corner, which is the exemption criteria. And there's a deliberate reason for that. And that's that the way the legislation has been designed, I don't foresee, and I think most individuals who watch this legislation, who are involved in this process, stakeholders, don't really foresee a scenario in which we actually get to the bargaining and final offer arbitration situation. Because what we're seeing publicly is that digital news intermediaries have made it very clear in the public record, in response to regulations in public communications, that unless they see a credible path to obtaining that exemption through the exemption criteria, they're going to take product actions that are necessary to make sure that the act does not apply to them, that they're not digital news intermediaries, that they do not provide access to news content. And that's exactly what we're seeing in the public. And frankly, it should be concerning to just about anybody who relies on these services to obtain news or to get access to news. Next slide, please. So I spoke about the exemption criteria, and we could go into detail about what this criteria is, and I will in a minute. I'm not going to read through all the criteria right here because I have a slide later on that kind of unpacks this criteria and explains what it actually means. But it's important to realize that in the lead line here, the Commission must make an exemption order in relation to a digital news intermediary if its operator requests the exemption and certain conditions are met. And I think this is really where the wheels really start to fall off on this process. And I intend to speak about two criterion, which are criterion 1 and 4. And like I said, I have another slide in a moment that speaks to those. So what the government did was it crafted a set of regulations that help explain what this criteria means. Next slide, please. And so I want to speak for a second about those regulations. To use something of an apt metaphor, I'm not going to bury the lead on this one. The draft regulations didn't work. The consultations closed 2 weeks ago. Google came out quite clearly and released their response to the consultations publicly, expressed continuing concerns about whether or not they foresee a path towards exemption being a workable solution. It's worth noting that various news media organizations that represent large swaths of news services in the country, acknowledge that yes, some of the criticisms that Google has and some of their concerns are quite legitimate. And I have only put Google in that camp right now because, as it's quite well known, Meta has already taken product action to make sure that news is not made available on their service so that they will not be scoped into this legislation effectively. These regulations were really important, and I think they're really important because these were the final legal instruments in this entire process, a final opportunity of sorts to convince digital news intermediaries to not take product action like they're contemplating, to not remove news from their platforms. And so it was very important that these regulations are right. The consultation period closed. The government is now assessing response to these consultations and how and whether they can actually create final regulations that address these concerns and avoid a scenario that I think most parties and most stakeholders want to avoid is now going to be up to officials at Canadian Heritage and political actors. Next slide, please. So why didn't these regulations work? You'll see that on the left, what I've put is the Section 11 criteria. That was the criteria I had. That's the actual criteria in the legislation to obtain an exemption. And on the right, I have what we're calling the deeming criteria, which was in the regulations. And the reason I'm calling it a deeming criteria is because the regulations cannot specifically modify what the legislation actually says. The Commission is responsible for interpreting the exemption criteria, and the Government and Council's regulations can't fetter the CRTC's discretion in that regard. So what the government did was they crafted regulations saying, if you do this, if a digital news intermediary does this, if its agreements meet this condition, the CRTC therefore must consider that it does this. That is to say, it meets that exemption criteria. So you need to really have a sense of what those regulations and what those deeming criteria require to get a sense of whether or not that's actually achievable from a digital news intermediary's perspective. And of course, if you're a stakeholder on the other side, if you're a news media stakeholder, it's really important that those stakeholders can understand what those criteria are so that you can actually negotiate commercial agreements that are consistent with that criteria. So if we look at number one, the legislation requires that fair compensation is provided to news businesses for the content that's made available by the news intermediary. Well, in the abstract, that is very difficult to understand what that means and how to negotiate a commercial agreement with individual news businesses based on that. So the regulation says agreements would meet the criterion of fair compensation if compensation for every agreement is within 20% of the average relative compensation of all agreements, meaning within this 20% band, if they're within that 20% band, it meets that criteria. Obviously, you can imagine that there are certain organizations whose value of their news may be significantly higher or lower. Whether that 20% reflects an actual marker of fair compensation remains unclear. If we go to condition 4, they contribute to the sustainability of the Canadian news marketplace. Again, very hard to understand what that means if you're negotiating in the abstract. So the regulations crafted a formula, and you can see it in the bottom right corner. I'm not going to unpack that formula because I have my own questions about it, but ultimately it says that, digital news intermediaries have to provide a certain amount of compensation to news businesses to contribute to the sustainability of the Canadian news marketplace. And in the case of Google, public reports are that would be approximately $170 million in which they would have to provide to eligible news businesses. That is a complaint of Google's that is too high of a threshold, and it was higher than the estimates that they prepared for. Next slide, please. And I'll just mention one more of these criteria, in that part of the legislation is designed very deliberately to assist certain organizations, certain news businesses that need support more than others. And those include independent news businesses, news businesses that represent Indigenous news outlets, and ones that represent official language minority communities. These are really important policy goals. They're laudable policy goals. We see them across communications industries. But the way the legislation designed it, the commercial agreements that digital news intermediaries must enter have to provide a significant portion of independent local news businesses, ensure that a significant portion benefit from them and they contribute to their sustainability. Well, the deeming criteria essentially says that the proposed criterion will assess if agreements support a significant portion of independent news businesses in local markets. If a DNI reaches deals with all collectives representing any group of 10 or more independent news businesses operating local news outlets, then it meets that condition. Essentially, what that means is if you want to be eligible, if a DNI wants to be eligible for an exemption, it cannot leave out any group of 10 or more independent local news businesses from that, essentially providing those organizations a veto on whether or not the DNI can obtain an exemption order. And the same thing applies with Indigenous news outlets and official language minority communities. And so these are the types of questions that digital news intermediaries are currently grappling with. Eligible news businesses are working in the background to assess what the value of their news is so that they can actually enter these commercial agreements and negotiate with digital news intermediaries. But in order for that to happen, what we really need is a process in place that's workable and works for stakeholders on all sides. Otherwise, we won't see stakeholders coming to the table. Next slide. And so my main question I had when this all began was like, what happens if news is removed from digital news intermediary products? Is that something that can be reversed? Is it something that would be reversed? That remains unclear right now. And the only solution to this is really to find a workable solution for the regulations to give digital news intermediaries comfort that they can enter this process in a workable manner. And we're going to see over the coming months whether or not the government can actually achieve that. So I'm going to turn over to my colleague, Scott Prescott in Ottawa, who is going to take us away on broadcasting regulation.
Okay. Thanks, Paul. I see you went Tyler today. I didn't realize that we were in a Tyler society, so thought I'd point that out. Welcome, everybody. I am Scott Prescott. I'm practicing mostly in the broadcasting regulatory side of things for a couple decades, maybe a little longer than that. I'm going to talk to you today about Bill C-11. And for those online, I am here in Ottawa. I'm not in Toronto. We're going to talk about Bill C-11, the Online Streaming Act. It was acted in, it received royal assent back in April of this year. It was a long, drawn-out legislative process that started in 2020, November 2020, with Bill C-10. And I won't go on about that, but my focus can be on sort of 4 key changes that have made to the Broadcast Act as a result. They're listed there on the slide, and then after that I'll talk a bit about the CRTC's process that they've implemented or started as a means to implement their new mandate under the revised Broadcasting Act. So the 4 key ways are that the Act has been amended. First, that it gives Commission the express authority to mandate to regulate online streaming services. It provides the Commission with the authority to impose fines for administrative monetary or administrative monetary penalties on those it regulates. The third thing is that it prioritizes programming services, including certain types, including content created by and for BIPOC communities, as well as other types of programming that are experiencing challenges, such as community media and news. And the final thing that I'll talk about is that it removes the Part 2 license fees, and the Commission's authority to impose Part 2 license fees. I'll talk about them in a little more detail. Next slide, please. Online streaming services, as I mentioned, this is probably the most significant change in the Act. It's the name of the Act, of Bill C-11. It brings streamers into the regulatory fold for the first time. It specifically defines an online undertaking as an undertaking for the transmission or retransmission of programs over the internet for reception by the public by means of broadcast and receiving apparatus. It's a very broad definition, captures a lot of stuff online. Unlike traditional broadcasters, online streaming services are permitted to operate in Canada without a license or a need for an exemption from licensing. However, the Commission has the authority to impose regulatory obligations, require them to register and impose regulatory obligations on them. It did that recently, and I'll talk a bit about this later too, when it imposed a registration requirement on certain online undertakings that earn annual revenues of more than $10 million a year. The Commission also has the power to impose conditions of service, which is similar to the power the Commission's had in the past to impose conditions of license on traditional broadcasters. In fact, conditional license lexicon has been removed from the Act altogether. We're now talking about conditions of service for both traditional broadcasters and for online undertakings. Another change that is related to the online streaming amendments is social media. There's specific exclusions in the Act for social media. Contrary to what a lot of people think, the Act does not prohibit the regulation of social media platforms. The Commission is permitted to regulate them, specifically where the operator of the service uploads programs like podcasts to its platform. It even allows the CRTC to regulate user-generated content in certain circumstances which are set out in the Act. And those circumstances are when the user-generated content is uploaded to the social media service by the provider of the service, or as otherwise prescribed by CRTC regulations. And there's a few criteria that go along with that. Next slide. So the second thing that is a significant change is the Commission's power to impose fines and or administrative monetary penalties, AMPs, for non-compliance. This is new. The Commission's never had this authority before. Till now, they had to rely on other mechanisms, short-term license renewals, mandatory orders. In some cases, in extreme cases, they would threaten revocation of licenses. And now the Commission can impose fines, and they can be significant. When you look at the slide, there's numbers there. It's, for individuals, it's up to 25,000 for first violation, 50,000 for subsequent violations. For corporations, it goes even higher, 10 million for first violation, up to 15 million for subsequent violations. These are maximum fines, and it's unlikely that they would be imposed, especially for a first offense. And the Commission also still retains all its other powers to ensure compliance. So it's likely going to continue to use those mechanisms. And the Act actually provides that the purpose of the AMP power is to promote compliance and not to punish. And I think for that reason, I suspect fines that are imposed will be well below the minimum. And they'll be used more, and the Commission will use them more as a last resort if there are other mechanisms to be able to address, ensure compliance with their requirements. Next slide. Okay. The third thing is that the Act prioritizes certain types of programming and programming services, particularly programs created by and for underrepresented groups in Canadian society, Indigenous peoples, Black and other racialized communities, as well as other groups like official and minority communities, have much greater prominence in this new version of the Act. Just to give sort of one example, there's some examples of on the slide of a number of times that certain terms are used. Indigenous appears in the Act now 19 times. In the previous Act, it also includes a definition of Indigenous peoples. In the previous Act, the word Aboriginal was used and it appeared only twice. There are 9 policy objectives now in the Act relating to Indigenous peoples. There were only 2 in the previous version. The same is true for the other underrepresented groups. There are new policy objectives and other provisions that give the Commission enhanced sort of authority and mandate to regulate in a way that supports equity-seeking groups in Canada. I mean, in addition to that, federal government has issued a draft policy direction to the CRTC, and it did that back in June, and it requires the Commission to prioritize Indigenous peoples, regulatory change for Indigenous peoples, equity-seeking groups, and OLMCSs. And there'll be a 2-year window for the Commission to do that. That policy correction is not yet in force, but it should be soon. And then it should also be noted that the news and community programming are 2 of the things, of the types of programs that are challenged, and that the Act now identifies them specifically as being important, and that will require some mechanisms to support it. The other thing I'll just mention is that there is going to be a new definition of Canadian program. The Act provides, the Commission's always had the authority to define what a Canadian program is, but now the Act provides additional criteria for that. I mean, one of those criteria is whether Canadians have a right or an interest in a program that allows them to control and benefit from the exploitation of the program. But I think what that clearly means is that there's going to be a much greater emphasis now on ensuring that the economic value of the rights of Canadian programs remain in the hands of Canadians, and that will have to be reflected in the new definition. And there's supposed to be a proceeding in that sometime this fall, early next year. Next slide, please. Finally, the authority for the Commission to establish what are called Part 2 license fees has been removed from the Act. I mean, under the old version of the Act, the Commission could establish 2 kinds of license fees, Part 1 and Part 2. Part 1 fees were designed to recover the costs of the Commission's operations. Those still exist. There's a proceeding ongoing right now on establishing how those fees will be calculated going forward. They amount to over $30 million last year. Part 2 fees, however, were a regulatory charge that was just paid into the government. It was over $120 million last year. And those Part 2 fees can no longer be imposed on broadcasting entities. So that's it for the sort of the basic overview of the major changes to the Act. I'll now talk a bit about. If you'll switch to the next slide, please. Yeah. Some of how the Commission is going to implement this new mandate. I mean, in May of this year, the Commission set out sort of a regulatory plan. It had 3 phases. Phase 1 was to establish registration requirements and establish new financial contributions for online undertakings. Phase 2 is where the commission is going to look at both online and traditional broadcasters and readjust and establish new sort of regulatory obligations in terms of support measures that are needed to support Canadian and Indigenous programming. And then phase 3 will be finally implementing those new obligations, both financial and non-financial contribution requirements, and imposing them on online and traditional broadcasters. Next slide, please. So to date, there have been 4 proceedings that the Commission has launched as part of phase 1. 2 of them have already been decided, 2023-139 and 140. The Commission issued decisions on them back in September. In those decisions, the Commission established that registration requirement and conditions of service, modest conditions of service for online undertakings. As I mentioned earlier, they've set a $10 million annual revenue threshold for compliance with those, for the application of those requirements. Third proceeding is 2023-138. That's the proceeding that will establish the initial base financial contributions that online undertakings will make to the system, and will decide which production funds will receive that money. And then the fourth proceeding is the broadcast fees proceeding, the old Part 1 fees that the Commission is revising how they will be imposed on online undertakings and traditional broadcasters. There is a proceeding on that. Comments were filed. The regulations are supposed to come into force in April 1st, 2024. They haven't actually been finalized yet. Next slide, please. Yeah, so here we go. A lot of work over the next 3 years. I'll close with sort of a few comments on just where I think things are, where things will be going. Now that it's passed, I mean, there's a lot of work to do. It'll take years and multiple CRTC proceedings to implement its new mandate under the Act. When that work is completed, I expect the regulatory landscape to look quite a bit different than it does today on the broadcasting side. The Commission itself has identified sort of 8 areas that it's going to focus on. The first one is, of course, the contribution regime that's being developed for online undertakings, and then be revised for traditional broadcasters. It may include direct contributions to funds, but also there might be some Canadian program expenditure requirements in there as well. Second, the terms Canadian program and Indigenous program will be redefined. Third, there'll be a new approach to licensing traditional broadcasters. The expectation is that there will be an expanded group-based model for regulating particularly vertically integrated entities. Fourth, there will be a new framework for music, spoken word content. There'll be adjustments to CanCon requirements, or possibly, and Canadian content development requirements, and they'll be imposed on radio stations and on online audio services. The fifth is new measures to foster the production and distribution of diverse content. I mean, this is sort of is one of the core objectives of the new Act. There'll be new financial contributions, exhibition requirements, or must offer rules, new requirements relating to promotion and discoverability of diverse content, and those will be imposed on traditional broadcasters and on online streamers. There'll be new measures to support news and other types of local programming, like community programming. This could involve new funds or other supports. Seventh thing is that the Commission wants to ensure market access and to wants to establish new measures to protect market access and to address other power imbalances in the system. I think this will probably involve the independent services review that the Commission sort of promised years ago. And then finally, there'll be new protections for consumers that come out of this. I suspect that there'll be some sort of code of conduct, something like the television service providers code or the ISP codes that have been created before to protect consumers in this new world. So that's it. There's a lot of work to do over the next few years. You'll see 11 is thrown at. Sort of bomb in a minute. I'll pass things over to Julia Kennedy now, who's a partner here in Ottawa. Julia will address the role of Indigenous reconciliation, communications, policy, and regulations.
Thank you, Scott, for taking us on a brief overview of all the work you have to do in the next 2 years. My name is Julia Kennedy. I'm a partner at Fasken. I operate out of the Ottawa office. I'm a corporate commercial lawyer. I work with clients in the telecommunications space in a number of different areas. I'd like to start by acknowledging that I'm speaking to you from Ottawa, from unceded Anishinaabe Algonquin territory. I'd also like to acknowledge that reconciliation is an immense and evolving subject, in which there are very many perspectives, in which deserves a great deal more time and consideration than we can devote to today. There are many great resources that exist on this subject more broadly, and I would invite anybody participating today to engage with those resources and expand their understanding. So today will be a very brief discussion of the role of Indigenous reconciliation in telecommunications policy and regulation, which will hopefully form a bit of a starting point for further discussion beyond today. Firstly, I'd like to recognize that the background of reconciliation as it relates to telecommunications and some specific policies that have been introduced, how those relate to reconciliation with Indigenous peoples in Canada, and some pieces of where we stand today with respect to some of those policies. So as a bit of an overarching framework for this discussion, the policy tools that are available to the federal government traditionally are regulation, policy directives, and then underneath those funding and maybe more specific actions by regulatory agencies. Their role as the Crown, as relates to Indigenous communities that operate as First Nations, for example, is in that sort of state-to-state, nation-to-nation relationship, is more of a negotiation. Today's presentation, we're going to talk a bit more of the traditional tools that the government has employed in terms of regulation and some policies. So there are other elements to this that probably should be explored and we can touch on, but a little bit out of scope for today. So even before the Truth and Reconciliation Commission began its work in 2008 on the impact of residential schools, the 1996 Royal Commission on Aboriginal Peoples called on the Canadian government to adopt a national policy of reconciliation and regeneration in addressing the historical and ongoing impacts of colonial policy on the Indigenous peoples of Canada. One of the outcomes then of the Truth and Reconciliation Commission's reports in 2015 were certain calls to action that relates more or less tangentially to telecommunications policy, as they were not directly focused on that area. One of them being for the government of Canada to develop a national action plan and other concrete measures to achieve the goals of the UN Declaration of the Rights of Indigenous Peoples, in addition to adopting that UN Declaration as the framework for reconciliation in Canada. Certain calls to action in that report relate indirectly to telecommunications, including call to action 92, which called on the corporate sector to also adopt the UN Declaration on the Rights of Indigenous Peoples reconciliation framework in moving forward. So how this connects to telecommunication. One of the unique elements about telecommunications as it relates to reconciliation versus other industries or elements of modern life is the transformative and empowering effect that reliable high-speed connectivity can have for individuals and communities. At a policy level, this has been acknowledged by various governments and entities over the past decade in a number of ways. But only more recently has that recognition had a more particular emphasis on how it impacts Indigenous communities and First Nations reserves. There have been a few policy directions and statutory amendments related to increasing telecommunications access and reliability for Indigenous communities, but generally as part of a larger objective of increasing connectivity for Canadians generally who have substandard connectivity. Most of these policies have been focused around providing funding as one of the major tools for doing increasing connectivity for underserved Canadians. So in 2016, certain particular policies and regulations started getting put in place. So in 2016, for example, the CRTC established the universal service objective that all Canadians, regardless of where they live, should have access to reliable voice and broadband services on both fixed and wireless networks. So this began the CRTC's emphasis on underserved communities, broadly defined to include rural, northern, and Indigenous communities, as well as First Nations reserves. Subsequently, the CRTC converted the main focus of the National Contribution Fund, which is a fund established based on the revenue percentage contributions of industry participants, so telecommunications companies, switched the focus of that to from subsidizing voice to being a vehicle to fund broadband infrastructure projects for underserved communities. That fund has been supported by the Telecommunications Act and amendments thereto since 1998. And the switching focus has been since emphasized in further amendments that happened in 2021. So the Act currently says that the Commission may require any communications provider to contribute, subject to any conditions that the Commission may set, to a fund to support the continuing access by Canadians to basic telecommunications services. Also in 2016, the federal government launched the Connect to Innovate funding program and allocated a little over $500 million to that fund. So go forward a few years, and then in 2019 budget, the federal government announced a national target that 95% of Canadian homes and businesses would have access to speeds of at least 50 megabits per second download and 10 megabits per second upload by 2026, and 100% of households by 2030, regardless of where they're located in the country. So we are now sitting in 2023 at the tail end. 2026 no longer sounds like a futuristic date in a meaningful way. So I'm going to take us to look at some numbers as we have so to date. So in 2016, as the national average for households in Canada was that 84% of households did have that level of connectivity. Obviously, that was mostly within urban areas. Move forward to 2021, which is when the CRTC's Communications Market Report reports to, we have 91.4% of households with that level of connectivity. So that sounds like a success story and is really great. But when we break down those numbers by region, it's a little less encouraging. So I'll get to those numbers in a moment. So that objective of getting to 100% by 2030 also gave rise to the federal government's Universal Broadband Fund. The UBF plus the Connect and Innovate program has approved funding in around $3.7 billion for projects within Canada. There's provincial funding that has been provided through a number of different programs, depending on the province, also for projects to increase connectivity for underserved communities, both in terms of either fiber or wireless or other projects. There's been a diverse level sort of technologies employed, and that sort of diversity is probably necessary to connect to some of these remote areas. So we're going to look at the Universal Service Objective and the UBF funding and where did it stand. So according to the federal government in 2014, 79% of Canadians had access to high-speed internet. 2016, we got some funding implemented. 2019, this plan of reaching 100% by 2030 was announced. 2020, we've got another $3.5 billion or $3.2 billion in the Universal Broadband Fund announced. And then as of 2021, we have this 91% of Canadians being connected. the 2020 new number that's been reported has been 93% of Canadians having access to high-speed internet. So again, sounds great. And then 2026 is supposed to be 98% of Canadians. So let's look at the Communications Market Report that reports on the 2021 numbers broken down by region. So for the North, that reported as 2021, 49.3% of households were connected with that 50-10 megabits per second goal. 52% of rural households and 43% of First Nation reserves. So although these programs to date that I've just described have been targeting underserved communities, which does include First Nations reserves, for example, the success has been largely elsewhere than in the First Nation reserves, for example. So in 2016, before this funding started, we had 27% of First Nations households on reserve having high-speed connectivity, and we moved to 43%. So that's an improvement, but for the policy objective is really to get to 2030, 100%. There's a gap to be addressed. So what's next, and what are the tools that are being employed? So as of 2021, there's been policy direction from the federal government has been much more cohesive and given greater emphasis to the importance of Indigenous reconciliation in Canada generally. So after a lot of advocacy by the First Nations communities, Parliament did pass and adopt the UN Declaration of Rights of Indigenous Peoples. And then also in that year issued another series of policy directions and indications that they were going to be pursuing Indigenous reconciliation in a more focused manner. The speech from the throne, for example, in 2021, indicated a government-wide directive, to quote, that reconciliation requires a whole-of-government approach, breaking down barriers and rethinking how to accelerate our work, whether it is implementing all the remaining long-term drinking water advisories or implementing the UN Declaration on the Rights of Indigenous Peoples. The government is committed to closing the gaps that far too many First Nations, Inuit, and Métis communities still face today. So one of those gaps that I've just highlighted had been the connectivity gap. So there's been a few other specific legislative and policy directions put in place directly related to telecommunications. Earlier this year, for example, the government issued a direction to the CRTC on a renewed approach to telecommunications policy, which included as a key objective that the CRTC's decision should ensure that affordable access to high quality, reliable, and resilient telecommunications services is available in all regions of Canada, including rural areas, remote areas, and Indigenous communities. The CRTC has then called for comments on a review of the National Contribution Fund, the broadband fund. In particular, sought comments on whether the fund should be used specifically for First Nations projects or to connect reserves, and whether funding should be used for operational as well as capital projects. That proceeding is closed and we await the CRTC's determinations thereon. However, it could result in a significant portion of the currently allocated $150 million per year going to Indigenous communities and First Nation reserves connectivity projects, not just infrastructure, but also operations. So another thing that happened more recently was the need for a focused approach to addressing disparate connectivity levels between different Canadians and different groups of Canadians and Indigenous communities has been addressed in ISED's Spectrum Outlook that was published in August, in which ISED committed to work to address Indigenous access to spectrum through its licensing process, streamline its engagement approaches to reduce engagement fatigue faced by Indigenous peoples, increase engagement with interested Indigenous partners, subject matter experts on the spectrum access matters, etc. Participate in fora that discuss Indigenous connectivity and spectrum access, pursue opportunities to establish new fora and discuss Indigenous connectivity and spectrum access, and offer specialized support to Indigenous applicants to help them better navigate ISED's program requirements, technical hurdles, and access spectrum needed to serve their communities. So we have an increased focus in terms of funding getting to Indigenous communities and these policy directions, both to the CRTC and to ISED in terms of what their decision-making should be framed by with this focus. But there's a lot of, but those are some of the tools that the government has implemented so far. There have been some minor statutory amendments in the Telecommunications Act to try to get at underserved communities, of which obviously First Nations reserves still remain a member of that group. But there's other tools and other things that could be done. So in terms of reconciliation, those tools have been employed and they have to be followed through on if the government intends to reach its universal access objective. I will note that there's obviously a tension between these top-down federally directed policies and some other principles of reconciliation, being that it should be more negotiation between two nations of equal dignity, and that there should be consultation and respect for the self-governance of First Nations. So there is a tension between the federal government having an objective to reach 100% connectivity at that level within a certain timeline, and the autonomy of First Nations to choose to do that or not. So some nuances required. A lot of the hard legal tools that we have available to us, or that the government is employing, are not necessarily the only solution, but where they're employing both policy and regulation to make funds available and to streamline processes to, as Isaac mentions, reduce engagement fatigue and red tape. That's probably for the benefit of both the reconciliation process as well as the government's connectivity objective. It's likely that the current and many future governments will need to keep all regulatory and policy tools available as options to successfully implement their universal service objective, or at least to facilitate First Nations achieving the level of connectivity that they need for their communities. As a last thought, I would mention that there is a role for industry to play here, both as a reconciliation partner and as a service provider. Many First Nations have or are pursuing some degree of ownership or control over the communication facilities that serve their reserve. And they could benefit from sophisticated industry partners participating with them. Certain telecommunications companies in the industry have already announced or pursued certain reconciliation objectives. But I think it's sort of an ecosystem thing where all these tools need to be sort of brought to bear in order to get to that 100% by 2030. So unless there's any questions, I'm going to turn it over to my colleague, Kerr-Wilson, who is going to speak to us on the topic of AI technology risks and solutions. Take it away, Jay.
Thank you, Julie. Good morning. So I'm going to speak a little bit about some current initiatives in regulating and the rollout of AI systems in Canadian industry. So we can advance to the first slide, please. And again, AI is one of those topics. It's large, much too large to try and cover in 10 or 15 minutes. So I'm going to really focus on a couple of key initiatives. I know everyone's probably sick about hearing about AI and generative AI at this point, but I thought I'd just have a really quick introduction. So generative AI is a specific subset of AI that generates content. And so, ChatGPT being sort of the model where you teach it to recognize languages and patterns in languages, and then you give it a prompt, tell me a story about a dog, and it generates a story about a dog. DALL-E does similar things. It produces images based on information it has learned from studying the data sets of millions of images. Synesthesia for video and music gen, obviously, for music. And, there's been an explosion in the adoption of these systems. People are having a lot of fun seeing what they can do, how well they can mimic human behavior, whether or not they can fool humans into thinking that the content's being generated by humans. But with that comes obviously a lot of risks. And policymakers are starting to trying to get their head around the risks. And I just give one little story about ChatGPT, which I think is my favorite. So it was a lawyer down in the United States who used ChatGPT to craft a legal argument. So it gave it the prompt, give me a legal argument in support of whatever. And ChatGPT generated a beautifully written legal brief, including citations to case law. So he submitted it to the court. Turns out the case law was entirely made up. ChatGPT didn't know to research actual cases, but it knew that good argument had cases. So it just made up the cases it needed. And it was all perfectly formatted. So the court said, we're having trouble running down some of your sources. And the lawyer had to sort of admit what he does. And I think he's now facing disciplinary, perhaps disbarment proceedings. So I think the genie's out of the bottle, and the question is now, how do we tame the genie? Next slide, please. So it's here. MIT Technology Review did a study or a survey of business owners. Almost 80% expect their employees will use generative AI in their work, and about a quarter of businesses are not prepared to adopt AI. They have insufficient security provisions, privacy, and trust guardrails. I'm going to suggest maybe that 25% is a bit of an underestimation of how many people are actually not prepared because they haven't really thought about it. Next slide, please. So the first thing I want to look at is ADA, the Artificial Intelligence and Data Act. And if you're going to build a world-conquering AI system, I would call it ADA. I think it's a really good name for sort of the evil film version of AI. So it's part 3 of Bill C-27, and my colleague Chris Ferguson is going to talk more about Bill C-27 after the break. So I'm just going to focus on part 3, which is the Artificial Intelligence and Data Act. So the purpose is to regulate trade and commerce in AI by establishing common requirements and to prohibit certain conduct. And I want to be clear that government isn't looking to prohibit the use of AI. In fact, government is leaning very heavily into adoption of AI as an economic good. The government has realized that there's potentially billions of dollars of economic value to be derived from responsible adoption of AI. And there's a lot of international cooperation around making sure that there's what they like guardrails is now the new term. But identifying that unregulated use of AI comes with particular risks. Next slide, please. So the two types of harm that have been recognized specifically are biased output and harm. So biased output is output that from an AI system that adversely differentiates on one more grounds of discrimination in the Human Rights Act. So to use a simple example, if you trained an AI system to recognize pets and you only showed it pictures of dogs, then obviously it's not going to recognize cats as pets. And if you substituted cats for marginalized communities or historically disadvantaged peoples, you can see where you suddenly have a problem where if you're driving policy issues or benefits based on AI systems that have been trained with biased data sets, then you're going to get biased and potentially very damaging output. And harm is, physical, psychological damage to property, economic loss. It's sort of your classic definition of harm. Next slide, please. So I'm going to go through some of the provisions quickly. So Section 6 deals with the use of anonymized data. So obviously, in a world of wanting to protect personal information, you want to strip away personal identifying information from the underlying data as you're using this data to train AI. So there's a lot of emphasis in the legislation on transparency and disclosure. So you have to publish somewhere on a website the manner in which the data set has been anonymized, the use and management of the data, and any record-keeping requirements. So anyone can go and look and see how this is managed. Next slide, please. So I think this is probably one of the most interesting aspects of the legislation. So the legislation recognizes that not all AI systems and not all use of AI systems are going to cause risk of harm. So they've establish a class called high impact systems, but they haven't defined it. It's going to be defined in regulations to come. But people who develop or use AI systems, generative AI systems, have to self-identify. They have to sort of do a little bit of soul searching to decide, is the system I'm employing a high impact system based on whatever regulatory definition the government comes up with? And in particular, is the system I'm deployed likely to cause harm or result in biased output? So you have to assess and then mitigate against potential harms and put in place measures to monitor your compliance with these requirements. Next slide, please. Transparency. So you have to disclose if you're using an AI system, how the system's intended to be used, the type of content it's intended to generate, what mitigation measures have been in place. And there's, again, a lot of emphasis that we don't want to be in a situation where people are relying on AI generated content, thinking it's been developed by a human, or we don't want to sort of fool the public into thinking that AI content is human generated content, to the extent that could cause problems, trust issues. There's a duty to notify. So if you've deployed one of these high impact AI systems and you think that there's circumstances that could cause material harm, then you have to notify the minister. There's a lot of ministerial order powers in the legislation, one of which is they can order you to stop using the AI system. Next slide, please. And, what's the use of having prohibitions if you don't have a good set of amps? So in this case, the legislation deals with violations and offenses, which overlap. So breaches of the same provisions can give rise to either a violation or an offense, and the government can only pick one. So if they decide to proceed as if it's a violation, they can't then later convert it into an offense. And there'd be administrative monetary policies, regulations. A lot of the details of this scheme is being left to the regulations. But there'd be a designation of what provisions of the Act would be considered to be violations. The classification, which I can't wait to see as minor violations, serious violations, or very serious violations. The whole scheme of proceedings will be set out. So how the amps, how the violations are, in a sense, prosecuted, what potential defenses there could be, and how the penalties are assessed. Next slide, please. And then section 30 is offenses. It will apply to sections 6 to 12. And I'm just going to go over some of the other offenses. So providing misleading information to the minister. So if you're disclosing a potential risk and you aren't fulsome in your disclosure, so you mislead the minister, that in itself is an offense. If the offense is preceded by way of an indictment, there could be a fine of the greater of, not more than the greater of $10 million or 3% of gross global revenues if it's a business, and then a fine at the discretion of the court if it's an individual. Next slide, please. If it's preceded by way of a summary offense, then the fine is down to $5 million or 2% of global revenue, and not more than $50,000 if an individual. And due diligence is a defense if it's an offense. Next slide, please. So realizing this act is still before committee, the government has released a code of practice for people who are either developing and deploying or using generative AI systems, and kind of asking businesses to voluntarily adhere to the code while we wait for the legislation to come into force. So the key principles of the code of practice is obviously safety. Don't do harm. Don't have biased output. Fairness and equity. And this is, again, all about making sure that you are using balanced data sets and that there's some effort to assess and curate the data. And transparency. And this is where we have to provide a method to detect the AI generated content. So the teacher can hit a button and realize that the term papers turned in that day were generated by ChatGPT. And so all of this is to make sure that when people are engaging with AI systems, they can have the benefits of the efficiency of processing these millions of data points without fraud or malfeasance. Next slide, please. Human oversight and monitoring, so you don't just turn Hal on and let him run your company. You have to make sure someone checks in once in a while that Hal's not opening the bay doors. Validity and robustness, so you have to test to make sure that you've set thresholds for output, and then you're testing back against the output to make sure it's meeting the measures. And accountability, making sure that you have policies in place if Hal goes off, does something unexpected, everyone knows where the off switch is. Next slide, please. So I'm going to switch topics quickly. The next policy area where AI causes some concern is in copyright. And there's a couple reasons for this. One is the process of training AI systems, as I said, involves compiling data sets of hundreds of thousands, millions of images, literary works, all of which, or many of which, would be protected by copyright. And you have to make a copy, a reproduction of each of the items in this data set to compile the data set, and then to have the AI system study it. So arguably, unless there's an exception, that could be an infringement. But we're talking about infringements on the scale of hundreds of thousands of individual works. And the other issue is on the generation side. So when an AI system generates a new, because the generative AI is not just reproducing old things, it's supposed to create something new from what it's learned. What is the copyright status of this new thing? And so far, the case law and the examination seems to be works that are produced by AI are not protectable by copyright because there is no human element. There's no creativity. They're a really good parrot, but they're just a parrot. So, if a parrot tells you a story because it's heard excerpts of a book, what the parrot says isn't protected by copyright, and the parrot isn't an author under the Copyright Act. So it's sort of the same approach in AI. But also, depending on how good your training mechanisms are, if AI oversamples from particular works in generating its output, it may end up. So if a full paragraph of a novel ends up in an AI-generated literary work, there may be a case that there's been infringing reproduction. So in 2001, the government issued a consultation. It was concerned there was no, at that point, common definition of AI. It was concerned about the text and data mining, so scraping the internet, looking for data to train AI. But at the time, it decided there wasn't enough consensus to proceed. This was 2021. So if we can go to the next slide, please. October 12th, so earlier this month in 2023, ISED and PCH issued a new consultation on copyright. And this wasn't that, they didn't see in 2021. It's the development in the industry between 2021 and 2023 has now brought these into sharp focus. So it's doing a new consultation. It's very much a fact-finding mission. So there's an online questionnaire that you go through, and it's asking about how AI is employed, the kind of mechanisms in place, and with very much a focus on issues related to the text and data mining, and the authorship and ownership. Of course, the issue is there. So there's people who say there should be an exception to copyright to allow for text and data mining to train AI, and people who own content say, gee, we'd like to have some sort of form of remuneration. So those are the kind of issues they are grappling with. Next slide, please. So I'm just going to leave you with a few strategies in this interim while we're waiting for the consultations, we're waiting for the legislation. You can cover yourself a lot with your commercial agreements, have provisions that assign and deal with risk, have reps and warranties. Develop the AI policy. If you're using AI, you're going to have a policy at some point. You might as well do it now. Consider third-party rights. Make sure you're not putting proprietary information at risk or your customer information at risk. Be prepared to comply with the legislation when it comes into force. So I'm going to leave it there. I will say I want to acknowledge the help and the work being done by my colleague Eliane Albogan in Montreal and Adele Ambrose in Toronto. They've both done some creative, really good writing about this. We have bulletins on our website. Please check it out. We're going to go to, I don't know if I know if there's questions or not. Okay, so we have a break now. Please come back after the break for Chris Ferguson to talk about Bill T27. 1020, we're going to come back.
In the Toronto office here, and I'll be talking about Bill C27 and sort of developments that have taken place around this bill. Next slide, please. So what's in Bill C27? Jay already mentioned the Artificial Intelligence and Data Act, so ADA, but there's also the Consumer Privacy Protection Act, which is the privacy reform portion of it, which would replace the privacy portions of PIPEDA and modernize the federal private sector privacy regime. And the second one is the Personal Information and Data Protection Tribunal Act, or just Tribunal Act, because otherwise it's a mouthful, which establishes a tribunal that can review the findings of the Privacy Commissioner and the orders of the Privacy Commissioner, and also impose monetary penalties, which we'll talk about shortly. And next slide, please. So a quick history and status of the bill. It was introduced in June 2022. It was a second go at federal private sector privacy reform. ADA was the big surprise there. Otherwise, the CPPA and the Tribunal Act are fairly similar to the first iterations of it. Second reading was on April 24th, 2023, and now it's in industry committee. And since then, the government has released information on proposed amendments and actually the text of the proposed amendments to the privacy portion. Next slide, please. So what are these proposed amendments? If anyone's it's the newest development with this bill. So next slide, please. So for the CPPA, the amendments are relatively minor. So one would be acknowledging privacy as a fundamental right in the preamble of the CPPA, as well as in the purpose section. But the purpose section and the preamble already did this in some respects, sort of acknowledging that privacy is a right, just not a fundamental right. And this was asked for by the commissioner and also some civil society groups. So that is going to be inserted there. The second is amendments for rights to minors. The CPPA already had provisions deeming the personal information of minors to be sensitive personal information. This would go a step further and say that organizations have to consider the specific impacts and vulnerabilities of children when determining whether to process the personal information of children and whether it's appropriate. And sorry, I meant minors there. And finally, there's a minor tweak to the enforcement mechanisms, clarifying that the compliance agreements which the Privacy Commissioner can enter into with organizations can include financial considerations. So monetary aspects to them. Next slide, please. The proposed amendments to ADA are more significant and the text of them has not been released. But the first one is defining an initial list of high impact systems. One of the criticisms of ADA is that it's missing certain details. And that was also what is a high impact AI system to which many of its obligations apply. The government would propose to include systems that are used in employment decisions, eligibility for services and pricing, biometrics, and content moderation and recommendations for search, social media, and other online communication platforms as high impact systems. And you can see a lot of these, you're talking about individualized decisions. So there's quite a bit of overlap in terms of with privacy laws, because you can't make employment decisions without processing personal information, et cetera. The second would be promoting the alignment between the EU and OECD standards for AI systems, including the definition, using the OECD definition of AI systems, which is more sort of in keeping with our current understanding of what AI systems are. It refers to models, it refers to inference. So there's that. The third amendment is differentiating obligations across the AI value chain. So that is looking at the different players in the AI market. So developers of models, developers of systems, persons who make those systems available, and system operators, which each have their own set of obligations. And finally, the government proposes to introduce provisions with respect to general purpose AI systems. So the ChatGPTs of the world, the DALL-Es of the world, and have obligations with respect to risk assessment, mitigation testing, monitoring, and then in certain cases, content identification. So you can see really a lot has happened in the years since ADA was introduced, and sort of this brings it forward in sort of the current understanding of what AI systems are. And you can see what are the high impact systems, there is overlap with what you'd have to do under privacy laws. So next slide, please. So turning back to the CPPA, and what's the biggest issue there? We only have 15 minutes, so we're going to have to sort of hit the highlights. And I think at least that's enforcement and penalties. Next slide, please. So the CPPA would give the Privacy Commissioner new powers, including order-making powers. It establishes a tribunal, which we discussed, which can impose penalties. The CPPA does provide for those administrative monetary penalties, new offenses and much higher fines, and also a private right of action. And so why should organizations really take note of this? Well, if you look at what the CPPA does, it turns a lot of existing Privacy Commissioner guidance, which is non-binding, into binding statutory obligations, and then backs them with monetary penalties, the ability for the commissioner to issue orders, and then the new offenses and fines. So let's talk a bit more about those. Next slide, please. So the new commissioner powers, the big one is the order-making power, and it's something the Privacy Commissioner had asked for a long time. And so those are orders to take measures to comply with the CPPA, stop doing something that's in contravention of the CPPA, comply with terms of a compliance agreement, and sort of make public any measures that correct an organization's practices. And of course, the commissioner can recommend penalties to the tribunal, which can then impose them. Next slide, please. So we talked about the new tribunal. It hears appeals from the commissioner's findings and orders, and it can impose those penalties and has the power of a superior court of record. Next slide, please. So that's where actually penalties will be imposed. But what are those penalties? Well, the maximum penalty a tribunal can impose is the greater of $10 million or 3% of the organization's global gross revenues. And there are defenses for due diligence and double jeopardy. And these penalties relate to only certain provisions of the Act. But, it's quite a bit of them. It includes things you'd expect, like, penalties if you don't maintain a privacy management program, penalties with respect to consent, consent with deception, safeguards of personal information, et cetera. So these penalties can apply on quite a broad basis in the CPPA. Next slide, please. Offenses and fines. So PIPEDA does have offenses and fines. So these are quasi-criminal proceedings that they would proceed under, except PIPEDA has up to a maximum of $100,000, whereas on indictment now, the maximum fine can be the greater of $25 million or 5% of the annual gross revenue of an organization. So the fines are much increased. Generally, the same sort of provisions are subject to fine, except new provisions of CPA with respect to de-identification. But otherwise, the amount of the fines is much higher. Next slide, please. And finally, like PIPEDA, there's a private right of action. You can an individual can make a claim if the commissioner or tribunal has determined there's a contravention, 2-year limitation period, and the person will have to prove damages. And so far under PIPEDA, that's been a challenge with claimants, but it's there. So overall, much more, you have penalties, higher fines, so there's much more teeth to it. And then the order-making power of the commissioner. And interesting of note, especially for in the federally regulated space, is the exact sort of lines between the application of provincial laws versus provincial privacy laws versus federal privacy laws has sort of been blurred. And you see the commissioners often engage in joint investigations. But now the Quebec law has penalty provisions, and the federal law potentially will if the CPPA, if Bill C-27 is passed. And so where and when provincial law versus federal law applies can have real monetary consequences once the CPPA is passed. Next slide, please. So let's talk a bit about the substantive provisions of the CPPA. Next slide, please. So there's quite a bit of ground to cover here, and we only have 6 minutes left. So I'll hit the highlights. I think that's sort of the more interesting for this crowd, but they're all important, and there's quite a bit of ground to cover. Next slide, please. So just again, turning to the purpose and scope, the Act has to recognize that protection of personal information, that you have to protect personal information in a manner that recognizes both the fundamental right of privacy of individuals, and that's the amendment there, And they need organizations to collect, use, and disclose personal information for purposes a reasonable person would consider appropriate in circumstances. So that's the general framework of the CPPA. Next slide, please. So there are new requirements for consent. The main one is that there's a plain language requirement now to the requirements for consent, and it's quasi-subjective. So you have to look at the plain language. Is it plain language for the group that you're trying to address? So if you have a product that is, or service that is highly technical, and the people who you're seeking consent are going to be technical users of of this service, plain language might mean a different thing if you just had a general consumer service. So it's a quasi-subjective plain language standard. And then in plain language, you have to explain the type of personal information that'll be collected, used, or disclosed, the purposes for which it's being collected, used, or disclosed, and those purposes have to be documented beforehand, the manner in which the personal information is to be collected, used, and disclosed, the consequences of that processing, and finally, the third parties to which personal information may be disclosed. And this is similar to the new Quebec requirement, but it has to be listed out in consent now, or under the CPA if it were passed. Pardon me. Next slide, please. So there are interesting exceptions to consent, however, in the CPPA. One of the criticisms of PIPEDA is that it's heavily consent-driven with fairly limited exceptions to consent, and sort of that has run in or been criticized when you're talking about the more sophisticated services, where it's hard to explain that consent. So the CPPA has two broader-based exceptions to consent, and the first is certain business activities, those activities that are required to provide products or services to an individual, activities necessary for the for the protection of information systems or network security, pardon me, and finally for the safety of a product or service. And so, in the communication space, these are useful exceptions because there's a bunch of technical uses of personal information, and for security uses of personal information that you could this exception could apply to. The second broad-based exception to consent is a legitimate interest exception, where the interests of the organization outweighs the potential adverse effect on the individual. Now, this sounds familiar. This is similar to what the GDPR has, or at least conceptually similar. And to do that, first, an organization has to have an assessment of what the risks are and potential adverse effects are, and also its mitigation measures. So it does require some planning to use this exception, but it's another sort of broad-based exception that can be used where appropriate if the CPPA were to pass. Now, in both cases, it's only for the collection and use of personal information. So these exceptions wouldn't apply to the disclosure of personal information. And also, they can't be, the collection or use has to be expected, and it can't be a collection or use that is for the purposes of influencing an individual behavior or decision. So something like advertising would be, likely not apply to these exceptions wouldn't apply to that. Next slide, please. Tying it back to ADA, the CPPA also has provisions with respect to automated decision systems. And these are extremely broad. They're independent of ADA, and it's an extremely broad definition. It's any technology to assist the judgment of a human through the use of what you'd expect, predictive analysis, machine learning, deep learning, and neural network, but also rules-based systems, which is sort of ambiguous. Does that mean sort of a flow chart? Is that an automated decision-making? It's an extremely broad definition. Next slide, please. So these rules will only apply where the system is used to make a decision recommendation that has a significant impact on the individual, which is, again, a term that has quite a wide latitude in how you interpret it. And if it is an automated decision system that could have a significant impact on individuals, then organizations would have to reply to individual requests to explain the type of personal information used for the prediction, recommendation, or decision, the source of that information, and the reason that led to the recommendation, prediction, or decision. Next slide, please. And finally, sort of going through the highlights of the CPPA, it clarifies sort of where everyone's obligations are when you transfer personal information to a service provider. So if you're the organization that says, hey, I'm going to use a service provider to process personal information, you have to ensure that there's an equivalent level of protection for that information while it's with the service provider. And that can be established by contract or otherwise. Service providers are required to safeguard personal information, and service providers are required to provide notice of any security breach or sort of unauthorized disclosure of that information to the organization on whom they're processing information for. And helpfully, this provision would clarify that service providers when they're processing personal information on behalf of another organization, are exempt from most of the CPPA's requirements, except for the requirement to safeguard personal information and to disclose any sort of data incidents to the person who processes personal information. So that's our quick run through Bill C. Next slide, please. So that's our quick run through Bill C-27. There's a lot more to discuss, but try to make use of the best of our 15 minutes. Thanks very much. Oh, sorry. And now I'll introduce Barbara, who will talk about production incentives in Canadian film and television industry. My apologies, Barbara.
Thanks so much, Chris. Good morning, everybody. I'm absolutely delighted to be here with you today. I'm a partner in the Toronto office, Corporate Commercial and Regulatory Council, and I've been involved in the communications industry, dare I say, for almost 4 decades. So I'm happy to speak with you today. My topic is going to be tough to cover, like all of my colleagues' topics, in 10 minutes, but I thought it was important that we talk about production incentives in the Canadian film and television industry. Next slide, please. We're going to touch today on a high overview of some of the incentives available in Canada, and then we'll do a little bit of a deep dive on the federal tax credits and the Ontario tax credits. Next slide, please. So the film industry has become a critical part of the Canadian economy, Hollywood North, as many call it. It has and is increasingly reaching new heights. The total production volume was an all-time high in 2022 of $11.69 billion. And in 2020, the industry generated 244,000 plus jobs. The statistics are going to be a bit skewed for a while because we had COVID in 2020 and the film industry was pretty much shut down. We spent a lot of time just on phones with producers trying to figure out how and what rules they have to follow in order to get to the set and keep it open, and whether actors could cross the border, and dealing with the unions and all of that to make sure that everyone was safe and well protected, and putting in all the protections necessary for everybody to be on set. But in addition to that, of course, we're now in the middle of just settled a screenwriters strike. We're still in the middle of an ACTRA strike. And it may be, well, today's news says maybe they're close to a settlement, but that is impacting both the United States, clearly, Hollywood and elsewhere, but also has a dramatic impact on the Canadian economy and the Canadian film industry. Next slide, please. So clearly, tax incentives reduce the cost of production, and it's very widespread in Canada. And so that is why we get a lot of interest and a lot of people coming up here to do their productions in Canada. There are federal and provincial territorial film and television production incentives across the country. We're going to go at a very high level through all of them in terms of what's available. But it's not always a tax credit. Sometimes it's in different kind of incentives, such as a rebate or a grant. And in all cases, the rates differ by jurisdiction. The timing of when you receive your funds differ depending on which province you're in or whether it's federal. And the amount of the benefit is also widely different, except that almost invariably it's based on qualified labor expenditures. How much money are you spending on people to produce the event? Next slide, please. So there's multiple incentives. Federally, you can get what we call a PSTC or a CPTC. I'll talk a little bit more about that in a moment. But the important thing is that they can be available simultaneously. You can't get a federal PSTC and a federal CPTC at the same time, for reasons that will be, clear when we talk about the difference between them. But you can get a federal credit and a provincial credit. And you might even be able to get 2 provincial credits. The question is whether the math works, because you have to spend a certain percentage in each jurisdiction, and it may not be possible to spread yourself so thinly to get them. But it's very common to get a federal and at least one provincial tax credit, and it allows you to produce these films or television shows at a much cheaper cost. In almost every case, there are excluded genre. They do differ, but almost always it excludes game shows, talk shows, news, weather, sporting events, award shows, adult entertainment, on the slide showing us pornography, among other specified genre. These are excluded almost always. Next slide, please. So I thought we'd do a very quick rundown of all of the possibilities, because not everyone appreciates that you can go almost to any province and at least get some benefit. People always go to CAFCO or federal, which is regulated by the Income Tax Act, as I'm sure you know. But we don't want to ignore the other provinces, especially if that is your home jurisdiction, and then you save costs by not having to move your offices to go and do a film or a production in a different jurisdiction. So federally, it's run by CAFCO, the Canadian Audio Visual, and you can either get a film credit, what we call a CPTC, or you can get a services credit. Again, I'm going to not talk about it too much right now, because that's one of the ones we're going to do a bit deeper dive on in a moment. In Alberta, there are two different types of tax credits. You can either get 22% or 30%, but if you want the higher rate of 30%, the Alberta-based production company must own at least part of the copyright. Interestingly enough, they don't define at least part. I don't know if that means you can own 1% of the copyright and that will do it, or whether it needs a higher percentage. In the case of federal, you'll see that they're much more explicit about what percentages are required. In British Columbia, it's also a tax credit. There are two different kinds. One where the copyright owner is not an eligible production company, in other words, a non-Canadian, and one where they are Canadian. And in that case, at least 50% of the copyright must be owned by the BC-based Canadian-owned corporation. It's not enough that they be Canadian, they must be BC-based. Next slide, please. Manitoba has tax credits as well. They also have two types, one based on salaries and one based on the cost of the production. In the cost of production, no copyright ownership requirements are applied, but in the cost of salaries, in both cases, no copyright ownership requirements. Forgive me. In New Brunswick, there is now a grant. It used to be a tax credit. It was converted. Not really sure why that was, but the copyright ownership must not be less than 33% for the interprovincial co-productions and 20% if it's an international co-production. So I'll just digress for a moment and say, as many of you know, Canada is a participant in many treaties for film production, and that would qualify it as an international co-production. And when it is an international co-production, there are benefits. Both countries can get tax credits and tax benefits on both sides, and they kind of split up who gets the employees, the producers, the directors, and how you divide up the expenses. So that's what I mean here by an international co-production. In Newfoundland and Labrador, it also is a tax credit. They don't speak to copyright ownership. Northwest Territories, it's a rebate, again, not specified in terms of copyright. In Nova Scotia, they've created an incentive fund. There's two streams, and it's based on the degree of Nova Scotia ownership. And basically, there are very technical rules about how to calculate that ownership. Next slide, please. Nunavut, we don't want to leave out our northern partners. It's a rebate. It's if you're an eligible production company, you have to demonstrate in this case that 100% of the copyright is owned by the eligible production, which is unique at a provincial level. In Ontario, production company must be a copyright owner for 25 years if you want the certain type of tax credit, the OFFTC. We'll talk about a little bit more in a moment. And if it's a services tax credit, the OPSC-TC, that's a mouthful, then there are no copyright ownership rules. And when I speak to copyright ownership rules, I'm speaking of whether the Canadian or the Canadian production company must own it, as opposed to allowing a non-Canadian to own the copyright. Prince Edward Island, no, they have a rebate and they don't speak to copyright ownership. And in Quebec, it's also a tax credit, and the corporation must own the copyright, but only while the production is ongoing is that a requirement. So once it's completed and the put in the can, as we say, then that obligation goes away. Next slide, please. Saskatchewan, they have two different streams. They are grants, and in the what we call the Saskatchewan stream, the applicant must be the owner or co-owner of the project, and at a minimum must control a share of the copyright proportional to the grant they're getting, basically. In the Yukon, it's also a rebate, and the copyright ownership is not specified. So that pretty much covers the country. Think where you want to go if you ever want to produce a Canadian production. Next slide, please. In my last few minutes, I wanted to just speak very quickly about the federal tax credits specifically, and then we'll touch briefly on the Ontario ones as well. So the federal tax credit, the CPTC, a production tax credit, 25% of qualified labor expenditures are eligible to a maximum of 15% of the total production costs. That is net of the assistance you're getting from CAVCO. That doesn't count in your qualification. Eligibility, 75% of the production services costs must be paid to or on behalf of Canadians. And a minimum of 75% of post-production costs must be incurred in Canada. So the goal, clearly, for these productions is to ensure that Canada gets the benefit through employment and production of a presence in Canada, the revenues generated from it, and the Canadian content piece of it, of course, as well. Next slide, please. In order to get the CPTC, you must be a Canadian-controlled taxable corporation whose primary business is film and television production, and you have a permanent establishment in Canada. Primary is not defined, but there have been commentaries to say primary means at least 50% of your business is in film and television production. Official treaty co-productions are eligible that I spoke about before. We said a moment ago that the corporation must own the copyright for at least 25 years. The corporation must control the worldwide exploitation of the rights over the production, and the production must be broadcast or distributed in Canada within 2 years of completion. Now, something not on the slide is the fact that they also control the revenues generated. So the Canadian producer, because they can give worldwide distribution rights to a non-Canadian other than Canada, must receive what is defined in the CAVCO rules as an acceptable share of the revenue. They don't really specify what all the limits around that are, but it does say that acceptable share of the revenue means no less than 25% of the net profits realized from the exploitation around the globe. And in order to determine what is 25%, there are very detailed rules, but essentially you have to follow industry standards. So you can't, say I'm only paying them, or they're only paying me 25 cents when really the production or distribution rights should be worth $1 million. So they do test those numbers to make sure that the Canadian is getting at least 25%. Next slide, please. So turning quickly to the PSTC, this is the services tax credit. In this case, it can be a non-Canadian that is the copyright owner. We'll touch on that in just a moment. Because it's not as Canadian involved, the available tax credit is much lower. So some people might forgo the copyright ownership in order to get the higher tax credit under the PCTC, and others, copyright ownership is king and they're prepared to take a less of a credit. So for the PSTC, it's 16% of qualified labor expenditure. The production has many minimum requirements, but among them, the minimum expenditure requirements has to be at least $1 million for a feature film, $100,000 per episode for each episode running of less than 30 minutes, and $200,000 per episode if it has a running time of 30 minutes. And like the PCTC, the production must be shown in Canada within 2 years following completion. Next slide, please. Like the actual Canadian, while they don't need to own the copyright, you do need a Canadian producer who is going to operate the production while being prepared and filmed in Canada. And that entity must be a taxable corporation. Their primary business must be the production or production services in Canada. They have to have a permanent establishment in Canada. Again, official treaty co-productions are eligible, but as mentioned, the non-Canadian may own the copyright. Next slide, please. And finally, we'll just talk about Ontario. I had to just pick one provincial jurisdiction. Of course, we know they all have them. But in the case of Ontario, credit is a basic 35% of eligible Ontario labor expenditures. And that can include the actors, the director, the producer, the screenwriter. There's a whole list of qualified people and categories on what they're worth in quotes. 85% of principal photography or key animation must be conducted in Ontario. There are certain exemptions for documentaries, which might be obvious based on factual information. 95% of the cost of post-production must be in Ontario. 75% of total final overall costs must be spent in Ontario. And like the federal, it has to be shown within 2 years of completion, but in Ontario. Next slide, please. The qualifying corporation must be a Canadian controlled, have to maintain a permanent establishment, and this Ontario production company must own the copyright for 25 years. If you want the OFTTC, in other words, the funding for at the higher level rather than the PSTC. Next slide, please. Finally, the services tax credit, it's calculated at 21.5% of all qualifying production expenditures incurred in Ontario. The Ontario labor expenditures must be at least 25% of the expenditures claimed, and they have those minimum expenditure requirements depending on whether it's a feature film, a 1 hour TV show, or a 30-minute TV show. I think that might be it. Next slide, please. So as I mentioned, like the federal, the services tax credit does not require Canadian ownership. Thank you so much. Pleased to be here with you today. Oh, sorry. I would like to introduce my Montreal partner, Christian Leblanc, and he's going to speak to us about the right to be forgotten. Thank you.
Thank you, Barbara. Good morning to all. It's a pleasure to be there. And I guess from Hollywood and the land of people who want to be seen, we're now in the realm of the right to be forgotten and people who would rather we forget about them. In the short period of time allocated, and I see that we've run into a bit of delays, I'll go straight to the point. This is about a right to be forgotten that is slowly creeping in the Canadian landscape. There's and that's the purpose of speaking to you today. There is a decision that was rendered by the Federal Court of Appeal on September 29th of this year, whereby the Privacy Commissioner of Canada had asked the federal court by way of reference whether or not PIPEDA, so that's the Personal Information Protection and Electronic Documents Act, would allow the commissioner to inquire and investigate complaints by which a person in Canada would ask that search engine, such as Google, de-index newspaper articles and the like to the name of a particular person. In other words, you would search for somebody, there would be newspaper articles associated with that person, but the Google search return would not give you those newspaper articles. This right to be forgotten possibility was first established by the European Court of Justice, and as I said, is now slowly getting into the Canadian landscape. The provincial privacy law in Quebec recently adopted as a section that speaks about the right for a person under certain conditions to be de-indexed. But it's what we're talking about here is on the federal level and on a complaint made at the Privacy Commissioner of Canada. Very quickly, what the decision concluded, it was a split decision. Justice Webb, Gleeson, and Fasken were on the panel. The majority decision written by Justice Fasken included Justice Gleeson, and Justice Webb dissented. Basically, what was at issue was point number one: does Google or is Google subject to PIPEDA? And if it is, there is an exception in PIPEDA for journalistic material. So if question number one is yes, question number two in the reference was, is Google subject to the exception? And I'll read it to you very quickly. The exception says that this part, that's the part one of PIPEDA, this part does not apply to any organization in respect of personal information that the organization collects, uses, or discloses for journalistic, artistic, or literary purposes, and does not collect, use, or disclose for any other purposes. And to go right to the punch, the majority decision agreed and declared that Google was subject to PIPEDA, so PIPEDA was applicable to Google. And on the second question, with respect to the indexing and search results that would lead to newspaper articles or other broadcasts with respect to news, does Google fall within that exception? The Federal Court of Appeal concluded that no, they didn't fall within that exception. Therefore, the commissioner can continue the investigation based on a complaint from a Canadian individual asking to be de-indexed in particular circumstances. What's very important is that, so Fasken was there and we represented a coalition of media who were very concerned that such a right could exist. Simply said, and there's a lot of nuances there, but simply said, it is always, we always have to be careful to erase history. You have to understand that this right to de-indexing is not based on the fact that the newspaper articles are false or that they would be defamatory. The criterias are not that. The criterias, and we don't have time to go into the details here, but for example, it's there is no public interest that remains in seeing these articles, and therefore we could de-index them. There's many other criterias, but that's one of the criterias. So we're basically based with that decision. The commissioner could investigate and make suggestion about the indexing. Very important point, though, the charter issue, whether or not that would be a breach of certain charter rights, freedom of the press, freedom of expression, has not been dealt by the federal court nor the Federal Court of Appeal. The coalition of media that we represented tried to broaden the reference to include whether or not such a conclusion would breach freedom of expression, for example. But the reference was not broadened to include charter issues. So there may be a second round on that. Who knows? But so as we stand, that's the decision. Google is subject to PIPEDA, and other search engines are subject to PIPEDA, and they don't fall within the exception of journalistic purpose. Justice Webb dissented and said basically that he saw Google in that model the same way he would see a retailer selling newspaper. In other words, Google was just helping a particular person asking for a search result to get to newspaper articles. And therefore, he would have concluded that that Google would be falling within the exception of journalistic purposes, and therefore de-indexing would not be permitted, and the jurisdiction of the commissioner, the Privacy Commissioner of Canada, would not be in play. But he's dissenting. So as we speak, that's not the state of the law. The delay to appeal or to ask permission to appeal at the Supreme Court of Canada is not yet elapsed. We don't know if the decision will be appealed, but and so I guess stay tuned. But there's another underlying issue that this raises also, which is the following. If Google or search engines are subject to PIPEDA and don't fall within that exception, it remains to be seen as to whether or not any search results that is given to somebody that would encompass private information as defined within PIPEDA, is that legal? Before you get the search result, does Google need to have the permission of the person of which the personal information is being published by Google that way necessary? And that's a big issue, because it could, as you already probably conclude, it could hinder the very business model of Google in Canada, because of course we all know how Google works. We all know how search engines works. It's an algorithm. You enter keywords, they give you the search immediately, and because of that, it's all sorts of information are being immediately given to the person asking for the search without any permission. So that also remains to be seen as to how this can be solved and the impact of that decision. But we thought, and the team at Fasken, the communications, telecom, and broadcast team, thought that it would be important that we tell you that right to be forgotten, the right to de-index, and how a search engine operates in Canada. And because there would be, according to that decision, subject to PIPEDA, the impact of that. And maybe the takeaway message is that, again, this right to be forgotten seems to take some or seems to be creeping in Canada. And we'll see if that decision will stay as it is or if it is appealed. I promised everybody that I would be short. There's many issues and things we can discuss about this decision. But keep it on your radar, as I'm convinced that this issue and this part of the law will evolve in the next years in Canada. So thank you very much. And on that, I'll leave the floor to my Ottawa partner, Leslie Milton, who will talk about current issues in spectrum and telecom policy and regulations. Thank you.
Thanks very much, Christian. I'm conscious that we're at time, so I'm going to move fast. But if there's an overarching theme to my presentation, it's that there's a lot going on in telecom policy and regulation in Canada and elsewhere right now. So in no particular order, I'm going to start with cybersecurity and network resilience. We operate currently under a 1993 Telecom Act. That act was actually quite prescient. It includes already as one of its key objectives to render reliable and affordable telecom services of high quality throughout Canada. So reliability is not new, but the importance of network resilience has intensified dramatically recently with our increased reliance on always-on everywhere communications, with cybersecurity threats, and with climate change. So this has resulted in legislative and regulatory activity. On the legislative front, there's new cybersecurity legislation before Parliament. It's Bill C-26, and that's how I'll refer to it. This legislation was tabled when the government announced that it would prohibit the use of certain equipment in 5G networks in Canada. So Bill C-26 is the law that would support that prohibition. There are two key parts to Bill C-26. The first is amendments to the Telecom Act. So you won't be surprised to hear they're proposing, though, to include a specific objective of Canadian telecommunications policy to promote the security of telecom networks. They would also include in the Telecom Act authorization for the government to direct telecommunications service providers to do or not to do anything that is necessary to the security of the Canadian telecommunications system. So, for example, prohibit the use of certain equipment, but it goes much beyond that. It could prohibit the provision of certain services or the provision of services to certain customers. The second piece of the bill is the new Critical Cyber Systems Protection Act. And that act would authorize the government to designate vital systems and vital services and require operators of those systems to implement cybersecurity programs, to report cybersecurity incidents, and to comply with cybersecurity directives. The bill has passed second reading in the House, and it's at the committee stage. Now, I think it's fair to say that the bill has broad conceptual support, but the devil's in the details. It is lacking details, and so there's significant concern about the absence of those details. What does it mean? So I think we might see at the committee level some proposals that may seek to define what kinds of conduct this legislation might prohibit, might scrutinize, might mandate. Next slide, please. So it's not just the government, our regulators are involved too. So the CRTC is in the game. Earlier this year, it mandated notification of major network outages on a temporary or interim basis, and it launched a proceeding to determine what a permanent outage regime should look like. So that's in play. At the same time, it said down the road, when it has time, it's going to have a future much broader proceeding on network resilience that would go back to first principles. What should it be looking at? What should it do in terms of emergency services? Should there be customer compensation? Should there be penalties for non-compliance? So this is a new area for the CRTC. Aside from regulating 911 services, which have always been intensively regulated, network resilience writ large has not been regulated. So lots going on in this area. Next slide, please. So spectrum policy and regulation. I just spoke about the CRTC. Our other communications regulator is Innovation, Science and Economic Development Canada, or ISED. ISED and the minister of that department are responsible for allocation of spectrum, which is, of course, the lifeblood for wireless services, and that's both our cell phone, our terrestrial wireless services, and our satellite services. So in May of this year, ISED released its spectrum outlook policy for the next 4 years. Julia mentioned it earlier. The policy identifies areas where it expects to see specific demand for spectrum and the policy themes that will guide ISED over the next 4 years in releasing spectrum. Not a lot of surprises there. Spectrum for commercial mobile, for the backhaul services that take our mobile services from all those towers you see, and also from fixed towers back to some central point of connection, for satellite, and for license exempt, and that's Wi-Fi and all of those IoT devices that are everywhere, exploding, that are running on license exempt spectrum. The policy themes are not a surprise, but they're very important. Spectrum as a driver for economic growth, rural connectivity, Indigenous connectivity, which Julia mentioned, very important to the department. The role of spectrum and wireless services in meeting our climate goals. And finally, last but not least, you've heard a lot about it, competition and wireless affordability. Next slide, please. So this is a very, very busy slide. It's the slide that summarizes where the department landed in applying these policy objectives to what it sees in terms of demand for spectrum over the next 4 years. And I'm not going to go into any detail on this slide, but it divides spectrum into 3 buckets: low band, mid band, and high band. That's because the different buckets have different characteristics. In the low band, you get a huge coverage area with your spectrum. Great penetration, goes through buildings, goes through rain, but doesn't carry as much data and isn't as fast. Mid-band is the sweet spot. It's the Goldilocks spectrum, balances all of those characteristics. As you can see from the slide, most of the low-band spectrum has been allocated, intensely utilized, not much going on there these days. Mid-band spectrum, lots going on. High-band spectrum, not as great coverage for sure, but very fast and lots of capacity. And that is, for example, we're seeing many of the new satellite broadband systems looking to use the high band spectrum. And so there's lots going on at the high band stage as well. Next slide, please. So just very quickly, C-band spectrum, that was mid-band spectrum, 3,800 megahertz, priority 1 spectrum on the slide you just saw very quickly. This is spectrum that was formerly allocated to satellite services, heavily used in the past by satellite services. It has been reallocated to terrestrial mobile services, which has insatiable demand for spectrum. And there is an auction that started Tuesday for this C-band spectrum, so we can expect results from that auction over the coming weeks. Next slide, please. And just very quickly on satellite services, last year ISED released a decision announcing some changes to its licensing and fees framework for both satellites and for the earth stations or the user terminals that you need to receive satellite services. It made some significant changes, and those changes have now been implemented. One of the changes is it now allows, there is a formal process to get a generic license for identical user earth stations, which of course is very important if you want to be like a service from a cellular carrier. And they rationalize license fees, which again is important to the competitiveness and affordability of satellite services. Next slide, please. And sorry to talk so fast. Back to the CRTC just quickly. Lots going on the broadband side. You heard a bit of this earlier from Julia. And you may have read the press on the first slide on these proceedings. This is the wireline wholesale broadband proceeding. The CRTC has mandated for a very long time wholesale access to the high-speed networks of Bell, Telus, and the large cable carriers, but there's lots of dissent over what that wholesale regulation looks like, particularly by wholesale-based competitors. So the framework was last reviewed in 2015. At that time, the CRTC made some important decisions about phasing out what was called aggregated wholesale access, which is very high-level wholesale access, a limited number of points of interconnection, to disaggregated access, which means wholesale-based competitors would have to connect at many more points of interconnection. And at the time, the commission said, oh, this new FTTP, fiber to the premise stuff, you will only get wholesale or mandated wholesale access to on a disaggregated basis. Fast forward to 2023, not much going on in terms of wholesale disaggregated access. So the commission launched a new proceeding to review this whole regime. Out of the gate, they immediately ordered an interim reduction in wholesale prices. They're conducting a detailed review of the regulated wholesale rates. And their preliminary view is that aggregated access should not be phased out. It should remain in place indefinitely, and it should be expanded to FTTP. So fiber to the premise for the non-techies is what Bell and Telus have been rolling out in the marketplace to support their higher speed services, well over 1 gigabit per second, and to compete with the cable company speeds over their cable infrastructure. Next slide, please. Also ongoing at the CRTC is their broadband fund review. I won't spend really any time on this. Julia mentioned it earlier, but they are looking at expanding what they will fund beyond the capital costs of building out new infrastructure to operational costs, to resilience, and as Julia mentioned, implementing an Indigenous specific funding stream. Next slide, please. And then also really in the broadband space, although we still talk about voice service in the north, the CRTC has had quite a long going proceeding on exploring services in the north for a lot of reasons to improve affordability up there. Reliability, quality is struggling in many places. There's not any competition, I think probably, or there's limited competition. I shouldn't say that, but there's not a lot of competition in many areas. And also really to explore ways to ensure that broadband access in that area will support both, educational opportunities, economic opportunities, and Indigenous opportunities. Next slide, please. Access to passive infrastructure. That's really getting into the nuts and bolts of telecom. But it is an issue of critical importance to the rollout of networks in Canada. Passive infrastructure refers to rights of way and to the supporting structures for telecom networks. So that's poles, underground conduit. You can't roll out a network without access to rights of way and to support structures. And the longer it takes, the more expensive it is, the longer it takes to roll out networks, and the more expensive your telecom services are going to be. So the CRTC has jurisdiction over some elements of access to passive infrastructure, but there are gaps, and the gaps are a continuing problem. I'll just flag one on this slide. Both the CRTC and the Federal Court of Appeal have ruled that the CRTC's dispute resolution jurisdiction over access to municipal rights of way, public rights of way, is limited to wireline infrastructure. So transmission line is the word in the act, and they've said that means just wireline infrastructure. Well, we're in a 5G world. That's a problem. 5G needs to go on signs. It needs to go on streetlights. It needs to go on signs. And those signs, guess where they are? They're in the rights of way. So this is an issue. The Federal Court of Appeal decision leave has been sought to the Supreme Court, and a decision on that is pending. Next slide, please. And just finally, on wireless services, of course, a lot going on in that space. I mentioned ISED, but also at the CRTC. A couple of years ago, the Commission determined that the big carriers, Bell, Rogers, Telus, and SaskTel in Saskatchewan, had to support MVNO access, that's mandated virtual network operator access to their network by regional carriers. And this is to expand competition, support the expansion of those regional networks throughout the country. The tariffs for those services have been finalized. And the tariffs, it's an interesting situation, but only for a telecom lawyer. The tariffs cover all of the terms and conditions except the rates. Go figure. The rates are to be commercially negotiated, and if you can't reach an agreement, you can go to the CRTC for a decision on rates through their final offer arbitration process. So there have been 2 recent decisions by the Commission setting those rates through that process, and that service is being deployed by some of the regional carriers. And with that, it's a wrap. Again, sorry for speaking so quickly. I know it's been a whirlwind tour of all of the issues this morning. I thank you very, very much for coming. And if you have questions, please don't hesitate to hang around if you have time. Speak to any one of us in the room. And otherwise, please feel free to reach out to us virtually. Thanks again.